We are having networking break for 15 minutes. We will meet after 15 minutes. Thank you so much. Members are Ahmed Zaki, Senior Vice President, Al Hamara UAE, Justin, Co-Chair, Venable LLP, New York, and David Sankar, Founder, Sankar IP, USA, Manuel Gizan, Founder, MGT Patent and Trademark Services, Hamburg, Dr. Dania Fahas, Arbitration and ADR Practitioner, UAE, and Indrail Sarkar, Principal, Fish and Richardson, USA. Please welcome them on stage.
Thank you very much. We wanted to start actually with this panel with a short introduction session, but now I don't know, we were introduced. Do you want to add something to this part? Okay, and we have two more panelists to come on the stage, but they will probably join us now. So I'm very honored to be the moderator for this topic, which looks to be the topic of the highest interest at the moment, actually, from the perspective of all the areas of IP law. And and I think that we will bring the interest now to more interest, right? I think it's not because of the lack of interest that we have less people, but mostly because of the yes. And I know this is not the first conference in Dubai, actually. So we start slowly and waiting for the audience to join us in our discussion. I would like to start maybe with your inputs, because we heard quite a lot today about the problematics. So we see that there are still a lot of problems unsolved generally with the AI and with the inventorship and ownership. But before we come maybe too closely to the inventorship and ownership, I would like to get your short input of each of you on the general artificial intelligence problematic you see, or maybe even whether you see it as a positive thing, that we have it now in our area and that we have to deal with it. You see it as the challenge which improves all of us and will bring us to the next level, or you see it a bit as a burden. Dania, would you like to start?
Thank you, Natalia, and it's a pleasure to be here and a privilege with my fellow co-panelists here, experts on the subject. Back to your question, Natalia, whether it is something for the great good or is it a challenge that we need to face? Another related question to that would be that it is a new problem, or is it an old new problem, and is it really shaking the IP foundations? Because the topic of this panel is actually this intersection between AI and the IP regime. Now, it's not the first time that technology faces IP. It happened before. We all remember the digital revolution, and the legal frameworks were adapted. But even before that, if you go back to the printing, okay, the printing was the first mass production industrial revolution, and actually copyright evolved from printing. And what was there actually was a change, a disruption in the means of distribution and in the means of reproduction. What's happening here, it's a new paradigm. What's happening now is the Creation Act itself is being impacted, and heavily so. So we're moving from machine learning with the old previous language models to machine creation. And this is a new paradigm. And this actually will entail, of course, not only legal issues and challenges, but will entail civilizational consequences. It will have ethical consequences. It will have societal considerations. And this is actually what I think is the radical change that we are observing today. And speaking of the legal issues, we'll have time during the panel to touch on that from the copyright perspective, on the feeding the AI machine, input, whether can be copyrighted or not, do we need the consent of the author or not, at the output level, the attribution, who owns the right, the machine, the human being. So it's a wide question, and when it was touched on before, when this AI revolution emerged with the new LLMs, other issues were prioritized, mainly data, privacy and security, and data integration. And regulators were really keen on regulating maybe these issues prior to the property, prior to IP. And today is timely time to discuss IP, and hence I think it's a good occasion. I stop here.
All right. Thanks. I'm Justin Pierce from Washington, D.C. It's a good general question, benefit or burden. I think AI, quite honestly, is a little of both. My view is that technology can be a good thing or bad thing, depending on whose hands it's in and maybe on what side of which argument you're on. And generally, a tool or technology really is neutral. It should be something that you use to create or to make something with, hopefully. Although many might argue that AI will destroy or take away intellectual property rights from those who are creators. I think in summary, though, on the beneficial side, I think we've heard from a lot of the previous panels, there's unquestionable advantages when it comes to increasing productivity. I think there's going to be incredible uses, and I'm talking in general with AI, not just generative AI, in terms of medical research, speeding up things that are certainly going to have benefits for mankind. On the flip side, as we probably all know from our careers and positions, if you're trying to preserve cultural heritage or art, it certainly is a threat if you can take something, an art form or art or creative work that some artist has put all this work into, and in a matter of seconds create an unauthorized, depending on which side of the argument you're on, derivative work, and make it seem like it's been done in the style of or similar to that original work of art. Certainly that's going to be damaging and deleterious to the market for that person. Particularly, I think all of us will have a certain level of sympathy if we're talking about a small artist or a local artist who may not have the resources of a big media company or something like that. I just provide those as some examples of how this is something that can be a benefit and a burden, and it's up to people like us and the governments that we all represent do a better job of trying to work together and come up with a holistic solution around the world. You've got a mic.
Yeah, I came from a patent perspective, so drafting a lot of patent applications, and I figured out that artificial intelligence is a very powerful tool, but it needs supervision. So you have problems that might occur because artificial intelligence is going for some of the most probable solution to a problem, but not creating new, really being like inventive in the concern of creating something or solving technical problems that have never been solved before. Might be like the artificial intelligence is going for solutions that, even if the solution is there, it might be like people don't know it already. But if it turns out that if artificial intelligence can solve the problem, then the solution was already there, at least in some different technical field or at some difficult pause, because it's all a matter of huge data and trying to find the most probable solutions and the most probable continuation for when you go to language modules and so on. So from my point of view, I use it mainly for different things that other than drafting patent applications. I use it for marketing, even using it for office actions, because when you go to office actions, the prior art or the subject matter is mainly already disclosed. So you're not dealing with very confidential information anymore, but it's something that is already public anyhow. And then it can really be like helpful and reduce time on that point.
Well, I concur with all the point of views. Actually, I enjoyed a lot also the the sessions that was before. And normally I'm an optimistic guy. I don't like to look at the bad side of anything. And if we go a couple of steps back in time, this is the same thing. Algorithm, when it was first discovered by Al-Khwarizmi, I think 1700 something or 1800 something. They didn't know then that we are going to use it in many things, including the AI now we are starting to use. So I think it will be developed more and more, sometimes in a creepy way. As I was just discussing this now, they can make me speak in Spanish, Portuguese, or the same language, Italian or German. I don't speak all these languages, and they can make me say whatever they want me to say. Maybe against something which have discrepancies or I don't know, but also it will be used for very good things. We have to see it from this point of view, that we have to keep innovative while protecting the benefits and the greater good of the human being. Not only on a personal level, like using our AI tools, which they know, and I don't know how to say it, it or he or she. I'm not I'm not anti-feminist, but it's okay. But sometimes when we speak about the AI, we say he or she, and I know that he knows about me now more than he should or it should. But what's coming next with the quantum computing and the huge investment in this kind of technology, something that we should take it seriously. Unfortunately, not with the current legal frameworks and legislations all over the world, even with the EU Act for AI, which is still too general. But we should start doing something really serious about having a clear view, international and local-wise, to at least keep it within two banks. And when we speak about authorship, and we have to speak about liabilities out of ownership also. So that's it. Thank you.
I'm Indranil Sarkar from Fish & Richardson in the DC office of Fish & Richardson. I won't belabor the point you guys have all touched upon. I would take there are two aspects. So I'm a patent lawyer, so part of me is a technologist, part of me is a lawyer. And obviously, the lawyer side of me it compels me to take something that Justin mentioned very elegantly, that it depends on which side you're on, or whose hand the technology is in. And it's pretty obvious that there are lots of great advantages to generative AI and AI in general, and also a lot of potential of malicious use. But as the technology side of me, or the technologist side of me, it compels me to be an optimist, because I believe that in general, any technology that we have seen over the years ultimately it's beneficial for the most part, and that's where we end up adopting it. And I think that's true for AI as well. I think on one hand, we see a lot of malicious. We talk about a lot of malicious users. We are very fearful about a lot of malicious users that you can only imagine how it can be used in the hands of bad actors. But we also, as patent attorneys, we see that too. We are seeing a lot of new technologies being developed based on AI. Not only are they, they're spawning novel and great uses, but also countermeasures to fight the malicious users. So overall, I think in the long run, hate it or like it, AI is here to stay, and we just have to learn to live with it. And I think, like any other technology, we would reach a point where we have that balance and to be able to use it responsibly. And I can only hope that we're headed that way.
I get to fill out the panel. I'm David Sanker. I was with Morgan Lewis for a very long time, and I just launched my own firm, Sanker IP, almost exactly a year ago, February 1st. And also, I've written some book chapters on AI, and I have books with me to give away if you're interested in. I've got those to give away. So in terms of the question here, one of the things I think is that kind of people are going to use AI to do things regardless of the underlying framework. So in a sense, it's kind of like it doesn't really matter. It's going to continue to be used, and so in a sense, the real question is, well, what should we make laws do? And in that sense, I think, at least in the United States, both patent law and copyright law are based on the Constitution, which says to promote the science and the useful arts. And so the question would be, okay, does a change promote that? Yes or no? And I'm not going to judge that, but it's like if it does, then yes, we should make a change. But if we don't think it does, and there's some people who would argue that well, people are going to use AI to do things anyway. So why do we necessarily need to give it any more rights? Because people are going to use it anyway. And I don't necessarily agree or disagree with that, but it's an important question that we should ask. And in the context of ownership rights, I think it's useful to compare what the laws are in a lot of jurisdictions already, and in most cases the law is really clear that it has to be a person. So if you look at the U.S. law on patents or UK law or Europe, it's pretty clear it's got to be a person. But how many of you actually looked at the law, say, in Australia? You probably mostly haven't. I've looked at this because it's in the Davis case. They filed in Australia, so there was an opinion on this. And in Australia, rather than a usual assignment of rights, they have something called the Statement of Entitlement. And so a given business can say, I am entitled to this potentially because I am the owner of this AI system, so I'm entitled to it. So it's something that's like, okay, that seems like it makes sense, and maybe that's where we should go more generally. I mean, it seems like a reasonable way that it could go, and so it's useful to see what somebody else has already done.
Thank you very much. And I think, David, you made a very nice bridge to the key topic of our discussion today, right? Inventorship and ownership. And now we have the new word involved, the new term involved, entitlement. I am, as a patents attorney, also I'm a bit feel very secure with this word, but I am not sure how the copyright people would feel with this, because when we talk about the technical term and we talk about the company, maybe we can say, okay, it's a group of people working. Now the company is entitled to the result of this, and there are some agreements between and so on. But if we have one artist using AI, right, what would it be? And I really want to hear the opinion of also from all the sides. We have now the specialists in all the sides, right, in copyright and patents and trademarks. I would really like to ask you, how do you think, whether you believe that the concept of inventorship or the concept of creator, the artist, would be just skipped at some point, at least for those products, both technical and non-technical, and software related, right, both protected from copyright and patents. Would this concept of inventorship, we just don't need it anymore? Or you think we will still need this chain? Because currently in the IP, we always have the chain. We have the first created what is inventorship, right? We have somebody who gets the right to the product because he created it or invented it. And now we have the second, we'll talk about ownership. But it looks like now we are at the moment when it can actually skip, where we just go to the second stage. What is your opinion on this?
Yes, I mean, you're touching on much of the complexities here, Natalia. If you're talking patents, for example, and it's very interesting what you just mentioned, if the AI finds it, the AI model, there's no novelty. It's out there. It's using it sometimes to create something that is maybe not really absolutely novel. And it can be a threat to the novelty test. Exactly. Novelty and inventivity and the threshold. So this is maybe for the patent regime where we have some foundations here being a bit questioned. But I think really the main disruption is for copyright. Because when we're talking about AI, we're talking about data and content creation, and it actually overlaps with copyright. And if we're looking at this AI model, how is it working? Okay, it's processing data and input, a huge astronomical amount of work, data, text, and it's creating an output. That's the novelty here if we compare to the previous former models where it was just search engines, for example. They scrap text and data, but they're not creating a content. So basically, the argument of fair use or the argument of transformative use was raised, and successfully so. Can we import this now to the AI? I'm not sure. Because what's happening here, we have a content being created out of potentially copyrighted works, meaning that the output is potentially a derivative work, not transformative enough, maybe to be protected. And at the input level, copyrighted, non-authorized works might have been fed into the machine. So here we see all the complexities that we are dealing with. And here we see whether we can adapt the current frameworks, and perhaps we will be able to adapt. I mean, now 2 years after the breakout of the Gen AI, we're starting to have judicial decisions coming out and discussing these concepts of fair use, of transformative use, and so on. If we're not able to adapt, then we might, as David mentioned, think out of the box and look elsewhere and come with more tailored regime for that. Because we need to bear in mind, copyright, patent, IP in general, were designed around human creation. Okay? If we look at the length of the copyright, 70 years generally, not everywhere, after the death of the author. How are we going to apply this to a machine? The whole philosophical foundation is around incentivizing and rewarding. Can we apply this to a machine? But what we can apply is, if we think certificate of entitlement, in Australia, because it's not really completely a crazy idea, here what we're having is not maybe a rewarding system, incentivizing, but I'm not so sure. Maybe it's a return on investment, right? Because the company here invested in this tool, and it's not completely out of the box, but we will need to make adjustments. And we might stay with our current frameworks with some adjustment, or we might come up with a sui generis regime with certain adaptation. We cannot really imagine the death, lifetime, and 70 years after. It's going to be 10 years for a machine, or 20 years, max, because it will expire. Technology is fast-moving.
So,
Go ahead.
yeah, so I was just going to make a point, Thalia, that to your question about whether we should just skip the whole invention or inventorship ascertaining part and get to ownership. To me, I think there are two reasons. There are two primary reasons we identify inventorship. One is obviously the legal reason that you have to get your inventorship correct, and therefore otherwise your patent's invalidated. And I'm speaking only from a patent perspective. So that's one thing. So that's the legal requirement. But we also have this. We also have a human aspect to it. So when somebody is named as an inventor, there's a lot of data on that, and it's generally true, I think, that people like that. People like that being recognized as an inventor. That whether or not there's a financial aspect attached to it, whether they're getting compensated by the company, that's a separate thing. But that helps. But even otherwise, right? People, when they're identified or recognized as an inventor, that incentivizes them to be more productive. So I think, in my view, we should not just completely circumvent the inventorship aspects of it, because that I don't think is and I think that's counterproductive to overall inventive and innovation.
Right. I was going to add, just on that overall issue of authorship and inventorship, I have a very similar view, and I was going to say also, not only on the inventorship side, when you're talking about patents, is it important from, I would say, a societal or value reason to recognize those who are inventors, because you want to incentivize, whether it's through people are just solely created in their inventiveness and they're not worried about financial, or when you talk about industries moving ahead, much of that is driven by finances and aggregation of capital. So in most market economies, that's not going to happen if you totally erase the ability for a person or an entity to have those rights. On the copyright side, with respect to authorship, same thing. And I think probably it's even more personal. Most people don't have to be a lawyer or anything to understand this. Everyone likes music. Everyone likes art. Just think of your favorite artist or musician. What would happen if that person, if she or he was never able to truly profit off the music that you really love or the art that you really find quite thoughtful? So I think that's destructive in a way that's visceral for most people. Last thing I'd say, one thing for the future, Danya had some very good points. I think one thing that could be done, I like the thought of perhaps a statement of entitlement, but one thing that could be done, and we could take information from, is the process of this work-for-hire concept in the copyright world. I do think there is a way forward that makes sense in many of our laws that are similar to this, but similar to the work-for-hire, you can have or should be able to have a corporate entity step in place of an author and be able to own rights to a work that's been commissioned for a specific point at that work. What I mean by that is if you have software or something that's been created by a machine autonomously, I don't think the right answer is, okay, no one owns it. I think the right answer should be there should be some way for that company who spent the money in research and put these people together to come up with something for a specific purpose to leverage that, perhaps for a short term.
Yes, please go. I just have a follow-up question, but please.
I just wanted to say that one of the main issues that would make our discussion or controversial for a long time, that we are all trying to apply the current rules, legislations that is covering the regular patent and regular copyright processes on something that it is not regular anymore. As I said, I'm just giving an example. I am using AI as an assistant. I'm uploading, copy and pasting emails and say respond until I do something else and go back and check the response. If it's okay, I copy and paste it again. Makes my life easier. Hundreds and hundreds of emails are now finished within half an hour, not more. Let me tell you something. This is frankly what happened when they asked me to join this wonderful event. I did so, and I copy and paste the email, and I forgot to respond immediately. Then when I went back, I found that the AI, which is I think ChatGPT Plus, not only responded to the email, but make a choice for me and said that out of the agenda, you are able to speak about 1, 2, 3. So you can respond saying, so it's not normally, when I start subscribing on ChatGPT, it was an app. He doesn't know Ahmed Zaki. He doesn't know what Ahmed Zaki is leading legal department in Alhambra. He doesn't know my experience coming, my background. After my contribution, Now he knows me more than I do. And let me tell you, the 2 sessions that I'm participating is his choice, or her choice, or its choice, whatever. So we are not speaking about something regular. To apply the current rules or frameworks that is covering the same subject, we are speaking about a new phase of human being history. We can use, of course, we can use the current laws and bylaws and even international, within the international standards to cope with this phase, but we still have to stop and think not only out of the box, out of space, because it's not enough. Out of box will be enough for the couple of not 10 years or 70 years, or for the couple of next 2 months while we are sitting now. AI is developing, and a lot of investment, billions, 500 billion are invested within Google, Microsoft, I think Amazon, to start something called StarTech or something like Stargate. And quantum computing is coming like a rocket through the picture. So I would say we have not to stop. We have just to start another phase, another lane, where thinking out of box, it would be great. Having examples like David said from Australia as a new thing to do, but this is very important. Thank you.
But I was also thinking about the lower end of creation. So you all know the famous Swedish band ABBA. So after more than 40 years, they after 40 years they returned to stage. But they didn't actually return to stage, but they had avatars on the stage. So from an ownership point of view, it's pretty easy because it's the same, because it's the same owner. The avatars are created by the people who also created the music. But where does it start? How much deviation do we need to have a problem on that?
So I was thinking of 2 things. One is that Justin just brought up, which is the works made for hire, which, if you think about it, well, did that, when the, say, first copyright laws were written, was that part of it? I don't think so. It came later when what was going on said, oh, well, we actually have sometimes people creating things for others, but we somehow sort of need to get some copyrights allowed. So we created that concept, and it's working now. Well, and then let's look at, say, within the US, we got fair use. It's like, well, fair use didn't exist at the outset either. That was created to handle the case, well, maybe there should be some exceptions under certain circumstances. And if you look at the 4 criteria that the US court created for fair use, they were created based upon the circumstances that were relevant at that time. And so when Justin and I were talking about this the other day, we were saying, oh, yeah, so if we were to look at the use of training an AI model right now and to apply the current fair use criteria, then it's pretty likely that it would be considered fair use, because that's just how it fits. But on the other hand, if you look at the reality of it, is that training an AI model is really extracting a lot of value from the creative work of some people. And it's like, so regardless of what the fair use exceptions currently says, it doesn't feel exactly right. So maybe we need to adapt those again in the same way that we have adapted them in the past.
And I think it's actually a very good starting point for us talking about more. I would like to come back to this inventorship and create a problematic, because I think I totally agree with you. Law should handle life, right? We don't need abstract laws which we just write. It should solve the problems that we have. And now we have this issue. Now we have people who are interested in what they did. They want to be named. as Justin said, right? They want to be named sometimes the first, sometimes the inventors have the problem who is to be named first on the patent application, right? We have, of course, the artists, the designers, the musicians. So we have everything. How do you think where these criteria are from your practical experience as patent attorneys working with the inventors, as copyright lawyers? When you use it yourself, how would you define this criteria where you can tell, okay, I need this, 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 now you can be called inventor. You're using it, or now you can be called the artist.
As a start, I think we should consider how much was the human contribution. Starting by prompts, how specifically are the data provided and uploaded to the system, how much they are. And one of the criteria might be how much was the human contribution to a matter or a subject or a novel or a piece of music. As much as the human contribution is considered in the process, I think this can be one of the criteria. It's not one criteria.
I was going to say, what you've just described is what the U.S. Patent Office released guidance on back in February regarding patents.
We did it together.
Yeah, you did it together. You worked together with the Patent Office. That's right. So it's basically the criteria is that, like, well, you know, we can't designate any AI inventors, but so they've got to be humans. But are the human contributions enough? And it's still the contours of what is enough is still unclear, because it's just said it's got to be significant. And so now the question is, well, what counts as significant? And so I expect, at least in the United States, I expect the contours of what is significant to be figured out in the next couple of years with the assistance of practice and us and others.
I'm still against using years. A couple of months, maybe a couple of weeks, if you want to have some time. But I don't think it would take years to be changed or years to be developed.
Maybe like originality also. It took some time to define it, and I'm not sure today we have a definition even for it. But I mean, it is challenging. Just to add to your point, David, and Ahmad's point, I think if we move also a bit little on the practice side, okay, there is really a practical, empirical problem here. We are talking about human contribution. How to draw the line, and are actually companies using AI tools documenting what they're doing? Because all what we are discussing now will bear consequences on new practices will have to emerge. So documentation, as Mona was mentioning on the previous panel, in order to make sure once you are in the courtroom that actually these are what I was using to feed the machine, this is what I obtained, this is to draw a line on my human contribution and how AI was used as an assistant tool. But again, how are we feeding the machine? Because here we have also the other rights holders. Because we're talking about ownership at the output level. But what about the works I'm using that are copyrighted and I did not secure the consent of the authors? If the regulations now, and we have the EU Act now requiring an opt-out from the authors today, how do we implement this? How authors are going to track that their works are being fed in AI models around the world? It's a practical problem. If we choose another system, because US haven't made their mind yet, I think it's a classical scenario. US takes a backseat when it comes to regulations, keeping the practice and industries to come up with their practices, and then they intervene. EU is a proactive regulator. Okay, they just want to mitigate risk, legal risk, and find solutions early on, and they enact acts early on to regulate. Now, maybe I don't know what approach is the most suitable for this type of problematic, but it's true that we would need a globally uniform approach at the end of the day. Because imagine that an AI model is training data in the US, but its operations are in Europe. You will have to comply, even if you are training your data in the US, where actually you don't maybe need to secure consents and authorizations from the copyrighted works authors. If you want to practice in compliance in Europe, now under the EU Act, you will have to secure authorization. This is a headache now for chief compliance officers in organizations. And they will have much on their plate to have all these issues under their radar. And we should not, this should not be underrated.
And I think this is we're kind of coming with a guidance actually to the legislators, basically, because I think, and because we have kind of a lot of questions, but I think you mentioned a lot of real answers, because of course we cannot ask the permission of all the people whose creations we are going to use, right, by training. So there should be some new mechanism. But it seems to be a very feasible mechanism, if I hear you correctly, that we can use it when you publish, then you can somehow secure whether your data are being used or not being used. Right?
If you look at the outcome, I mean, it's really derivative. You would know that it's what's said with copyrighted work that belongs to me, and I would like to be rewarded for that and compensated. Yeah. But again, it's really it's a practical issue to assess, and we still don't have really practical guidelines. That's what I wanted to say.
I was going to add, I think, just to add on to that conversation, I think part of this will be more will from all the different jurisdictions to go to their legislators, government, to at least start promulgating rules or some kind of guidelines that establish what I'd call a lowest common denominator, or some commonalities that many jurisdictions together can enact. But also with law, I think you have technological developments that are actually underway now. There are a number of tools. They're disparate. They're in the hands of many different people. Some are confidential and they're being developed. But every time you have a push in one direction in technology, you have countermeasures that respond to it. So there are thousands of different applications now, many that you all are aware of in different ways, where people are trying to track bits of data. Think about some of the technology that goes to digital watermarking, whether it's a musical tune. You can do the same with software and things like that. Those things right now are being developed in parallel. Obviously, many are probably the subjects of pending patent applications and are being kept secret. But I'm actually confident and optimistic, like Ahmad here, that I think some of this is happening in parallel. Obviously, the things that are more negative get more attention than the positive countermeasures. But if you think holistically, all of these are happening as well with us on a technological side, and those will have to be part of the solution. And then there'll have to be some agreement as to some technical standard that's applied so that you can track and trace when your bit of music, your bit of art, your data from a database is used in some way for training or something like that.
I think we started with coming to the practical advices, right? Where you can consider as a protection, maybe even before some legal regulations exist. You named already several things that the people creating or using AI can use, like beforehand. That we don't know how it will be regulated now, but we can imagine and we can think, okay, what should I already do now? What should I keep? Right, records of what should I keep? What should I estimate maybe myself and keep like the internal estimation of this involvement of the person, like, and so on. Do you have any other, the other panels, do you have any other more practical things to think about already now in this very unclear maybe situation?
Well, I'll take a shot at this. So, I mean, I think the problem is a lot more complicated on the copyright side of things as compared to the patent side of things, in my view. And the reason being that, as to David's point, as to how much is significant to be somebody to be an inventor, I think to some extent we already investigate that when writing a patent application, because one of the first things that we try to get to the bottom of when we're tasked with drafting a patent application is, what is the invention? What is that you think you have invented? What is that? It's novel, and then we get into obviousness and all of that stuff. And for AI-generated inventions, we've seen that in a wave of that in blockchain. Now we are seeing the same thing in AI. When you ask that question, it becomes pretty clear, oftentimes, with exceptions, that if it is something that if you're simply using an existing tool and all that you're doing is feeding the problem to it and it spits out a solution, that's not an invention, first of all, right? I mean, so the human contribution on the patent side, I think, can be filtered out relatively easily when you start questioning that. Like for something that has become garnered a lot of interest of late is prompt engineering. Is prompt engineering, can you get patent protection for that? And it really depends on what you're doing. If you're simply formulating a question to an LLM as anyone else would, it's probably not an invention. But when you start looking at, if you modified the prompt in certain ways to get to your final solution, or whatever it's spat out at you, you modified that to get to your solution. So that's where the human contribution comes in. That's what we have to, I think, from a practical aspect, at least from a patent side of things, that's what we try to filter out and then question whether those modifications are novel, non-obvious, etc. Then it becomes easier to manage that way.
Or maybe a copyright on the prompt engineering. Not only a patent, it can be maybe copyrighted, like the old problem of the software. It can be also another venue.
And actually, in terms of practical advice, I'm going to completely agree with what Danya just said. It's like, particularly because of the fact that the criteria are not clear, the answer is make sure you document it. And it doesn't necessarily have to appear in your patent application or something, but have contemporaneous information that says, these are the things we did, and particularly, if you can describe your work as like how we maybe used an AI tool to help us, but we're really clear on the human intervention, because the worst possible scenario is like 5 or 10 years down the road, you're in litigation, and then the opposing side says, well, you don't have an invention because it was just AI, and if you don't have any evidence, you could lose a patent. So I want to reiterate Danya's point about document the work of the humans.
That lab notebook data.
Yes, the lab notebook.
Well, at the European Patent Office, we have the problem-solution approach for whether a patent is granted or not. And just from my point of view, AI is not solving, AI as such is not starting to look for problems. So you need someone who is just like giving in some question that should be solved. And there are some decisions from the European Patent Office that go in this direction. It's like you need to have some technical effect, or you have some technical effect besides the algorithm as such, to get something granted, because only if you solve like a problem like the maintenance plan for a machine or something like that, using AI, only then it is granted. And I think we can stick to that, at least on the field of patents, just saying. But as Ahmed already said, the technology is developing so fast. We might have a look for the next 2 or 3 years. Ahmed said would we say like 2 or 3 months, but I'm like a little bit more
6 months.
a little bit more conservative on that point. But the thing is changing so fast, and the jurisdictions have to keep up with the development, because like in anything that was developed over the years. But the circles or the times for development are now shortening and shortening and shortening. Like we have law systems like here in the UAE that are based on the Sharia, which is based like a system that is going on the Quran, which is like 800 years ago. So 800 years. 1,440 years. It's 700 something. And by that time, of course, they didn't consider things like cars, planes, artificial intelligence.
I wouldn't go there. I wouldn't go there while me next to you. This is a controversial subject.
But
let's pass it.
But let's put it in this way. They had to develop the law based on the technical development that was happening. So
you have to go deep and deep, and you will find more answers to questions that was raised lately, which was not explicitly explained and understood in Quran, but in the interpretation of the verses, you might find a lot of answers. So let's skip this. I want to also add something. One more point. Recognition is not the only thing, or the revenue or the controlship of after recognition for a product is not the only one side that should be discussed. The most important also is the liabilities of owning a specific program or app and using AI not as an assistant like Ahmed is doing. I'm speaking about more and more usage in legal processes. We just saw an English judge said that he used AI in his court lately in design of buildings and projects, in medical and healthcare services. It's not an easy thing to say, or not even clear now, to say whose liability would be if I am an institution using a machine that, let's say, is built in Europe using an AI system developed in China, and we are using this in UAE. Which of these levels, the developer or the user or the institution, is more liable when it is recognized? And we speak about not finding a tumor or misdiagnose a disease, something really severe. I think we should take it from both sides, the recognition and the liability.
And I think that's a very good point, because I personally liked a lot this word instrument, right? Because we solve a lot of problems with inventorship maybe, and with authorship. If we say we just use the instrument, it doesn't create anything. But then we come to this problem. Who is liable and who is responsible if the damage is done? How do you think, should we, and I was on the conference half a year ago when it was discussed from the legal perspective, but it ended up in discussing it from the ethical perspective. How do you think, maybe practically,
I'm using this practical point because I have a discussion with one of my best friends ever. He's a doctor, and he's so proud about how much the AI have contributed to the healthcare industry, speaking about machines and medical care also, and medical industry. I mean pharmaceuticals industry. And I start to ask him, how do you use it? And like I said, he is using a radiology machine, X-rays or something like that, on a patient in UAE, while the machine itself is built in, I don't know if you should say the name or not, but in Europe, for instance, using an AI tool coming from Hong Kong. So I asked him a question: which part of these three phases are responsible if something wrong happened to the patient? And he stopped. He didn't answer. No one would know, because at some level, it's not a system, it's not an app like we are using now. The machine, the AI system itself, is developed after the subscription of the institution with the developer to use this AI, because they fed it with more data, which might be at some point not accurate enough, or maybe was not supervised enough. So this is a question that we should start by using the current frameworks, current legislations. but we would never reach a solution. I think.
But I'm sorry for pushing it, but I really want to try, to go at least in the.
We have to. Well, this is the
yes.
only way now we have.
Yeah.
Well, using it in medical treatments, like for detecting skin cancer or something like that, there are very useful AI tools. But there's still a doctor who's doing the final decision. So, of course, you will be the person in charge, even if the AI system is giving a wrong answer. So from my point of view, there is a person who is like using the tool. I just see it as a tool. Is the one, even if it's a very powerful and helpful tool, and might detect something that the human eye cannot detect, there's still someone in charge of the system or feeding data to the system, and this is, from my point of view, this is a person that should be responsible. Even if the things he does are not enough to be inventive or to be an author for something, because the human part is too little for that, is still the person in charge. So from my point of view, this is quite, at least this is my approach to this topic.
I'll conclude with you as an optimistic guy, but let's see what will happen.
Yeah, I was going to say, I essentially agree with that, that ultimately there's got to be somewhere in the line where it's like the buck stops here. So like in the cases where we've seen attorneys using AI that generate hallucinations, you can't just say, oh, the AI did that, it's not my fault. It's like, well, you're the attorney, it's your fault. And the same thing, it's like even the attorneys, if you have a junior associates doing work, it's your responsibility to review it, so you're responsible. So ultimately, there's got to be somebody at the end of the line who's like, this person is responsible.
Yeah, I would add here, it's a good question. I think three things here. One, no matter what, this is always going to be a case-by-case analysis type of situation. I think number two, in the world that we're currently in, whether it's in medical treatments, you had a very good situation where you almost have three different parties: the equipment provider, the AI system provider, the medical professional, him or herself. I can give you other scenarios I know of in real life. Let's think about a system that is used by creatives at an ad agency to create advertisements that are catchy, have a good hook line, and have an increased amount of sales for a particular product. Well, what if it turns out that tool being used, it increases the sales, but it's including false claims? It's saying this new vitamin can make you look 20 years younger, and then you get sued in the U.S. So then whose fault is that, right? So obviously you could say, well, it's the creative agency's fault. They should have been checking on this. But maybe they say, well, hey, we have ironclad agreements that we did with the provider, and I have no idea what they trained it on. That's why it made these decisions. Then you have a fight between those two parties. But ultimately, I think what we're going to have is case-by-case assessments where there's going to be some type of realistic judgment made as to the percentage of liability that maybe a party in that chain has had. And last but not least, if there's some sort of fiduciary responsibility or professional responsibility like we talked about for lawyers, you'll always have that area of liability where the buck truly does stop at the end of the road with any kind of professional that's using that system.
Yeah, I would completely agree that to me, in some ways, it's not, in certain cases at least, it's no different from what we have been doing so far. We are using a ton of tools in diagnosis, right? But if you misdiagnose, if there is a misdiagnosis, there's no question. You're not going to blame the ultrasound machine for that, right? You're going to blame the person who's reading that report and making a judgment call on that. So I think that in some cases it's pretty clear, perhaps in the medical field or the legal field, that ultimately it's a human person with whom the buck stops, and they will be responsible. And so in some ways it's not very different from what we've been doing so far.
Yeah, you agree?
Yes, I do agree. I mean, there will be maybe a sort of obligation of oversight shaping up, meaning you're using this tool, and as any other tool, you have an obligation to have an oversight on the result. And the same happened with the attorney who used also for his pleadings the AI without even checking and coming to the courtroom, and it was like a bit of a nonsense, a big scandal for the lawyer. But I mean, the lesson of the day was you can use AI, but just have an oversight. I mean,
Yeah, there was a recent situation in the U.S. where, they decided case law which just didn't exist. So that's clearly it's your responsibility to check it.
I think we're bad at it.
Yes, we are actually, unfortunately, out of time, although I would proceed with this discussion, and I think it would be interesting to meet again with the same panel in a year and to see how it's actually evolved, all this development, and whether we are still as optimistic as I think we at the end are. Thank you so much. You are very welcome to approach all the other panelists to ask the questions, but maybe we have time for 1-2 questions now also.
Yes, sure.
Please, if you have the questions.
Thank you. I have 2 questions. First one, we have half the panel from the United States. I wanted to ask you, for those practitioners, there's a new acting director at the USPTO, Coke Stewart, and there's also pending legislation for the Patent Eligibility Reform Act, PARA. It seems like there's a merging of a lot of entities that is more pro-patent owner and might modify patent eligibility rules. How do you see that taking shape in the next coming years, and particularly the next 4 years of the current U.S. administration, and how may that impact examination procedures at the Patent Office when it comes to prosecution? It's the first question. And then for Manuel, you had mentioned the problem-solution approach, and that how potentially it might not be a technical effect. Did I understand that correctly? If I did, then the question is, isn't the entire point of AI and these neural networks and computer systems is that you're enabling a solution in a computer that didn't exist before, that allows you to do things at a scale that a human being just cannot do. So is that not sufficient to satisfy that technical effect requirement?
Do you want to start with this question first, Manuel, maybe?
I have no answer to this question because there haven't been any decision on that point yet. But I do understand your problem, but I don't can give you a proper answer to this. I do understand what the European Patent Office says is like you cannot patent the algorithms of artificial intelligence because it's just an algorithm, and it's like a mathematical solution, and it's rejected from or excluded from patentability. So you always need like a additional technical problem to be solved by this to get it granted. So the algorithm as such is not patentable, but the solution in the use of the maybe, if it's inventive. So, but for all additional, we're just looking for first decisions on the courts, because the European High Court or the Grand Chamber of Appeal on the European Patent Office and the jurisdictional chamber are quite working on these topics because they are aware of it, but they don't have any proper solution yet.
Thank you. And David, Justin, Indranil, would you like to answer the first question?
Yeah. Regarding subject matter eligibility, so this problem has existed for 10 years. So don't expect any quick change to that. In particular, regardless of what any administration might want or any director might want, they can't change the law. The only body that can change the law is the U.S. Congress. And at this point, the Congress, I think the likelihood of passing anything significant is not very high. So I'm going to take an extremely pessimistic view and say it's unlikely that we'll see anything significant in a while. Do you want to just?
Yeah, I'll just say real quick, I agree. I think it's a great question. There has been a trend towards more pro-patent, I'll call it mumblings. things that maybe don't necessarily all end up in the law. I think there's certainly a push towards it. But at the same time, if you've been watching U.S. politics, there's been a huge aggregation of power behind the tech companies who it's in their interest in some ways to try to lower the bar when it comes to patent protection, because that gets in the way of leveraging some of their large platform capability compared to like an independent or small entity. So there's some interesting role with that. I'm only giving you sort of like look at what's happening economically now. And then last, I would say yes, really because of the stalemate in Congress in the U.S. and the division, it's very tough to get even very useful or practical legislation that would be helpful to many people through because of the dysfunction.
Well, I would just add anecdotally that I was on a panel in another conference recently where one of my co-panelists, he had actually compared the House bill and the Senate bill, and that came out in the last session of Congress, and he actually he found out that they were identical word for word. It didn't pass. So I completely agree with this, what the others are saying. So.
Any more questions? Thank you. Thank you, audience. Thank you, panel members. Now I would like to request moderator to do the honor to the panel members. Yeah. Next is Justin. This is for Justin. Indrail Sarkar. This is for Ahmed Zaki. This is for Manuel. I would like to request Mr. David to please do the honor to the moderator.
This is for you. Great.
Please come forward for group photo. That's fine, go back.
Some pieces here.
That's fine. Thank you, all the panel members and the moderator. Now, our next session is International Patent Protection Challenges and Best Practices. To moderate this session, I would like kindly invite Priyank Khandelwal, founding partner, Photon Legal India, and the panel members are Usman Khan, Principal, Fish and Richardson, USA, and Natalia Zaharova, European Patent Attorney, COPA, Denmark, David Sankar, founder, Sankar IP USA, Suchi Agarwal, Managing Director, IP Niti from India, and David Kellis, patent attorney, Kellis IP, USA. Please join me in welcoming them to the stage.
So we wait before we start, otherwise.
You can start, they will come and close.
Okay. All right. Is this the last session?
No, after that, we are having one more session, that is an individual talk by Mr.
Interesting. Hello. May I have all of your attention, please? Thank you. Thank you so much. So I don't want to be moderating a panel just before we break out for dinner. It's been a long day, I understand that. So all we need is your support so that we can wrap up quickly, because all of my other co-panelists are having a fantastic day. Let me just say that. And we want to also break out for the amazing dinner party we have. So by show of hand, if I can get some answers from you on who's freezing more. On a scale of 0 to Antarctica, how cold is the room for you? It's too cold, right? I mean, I can't see people clapping. Everybody is folding their hands. So if I can have just one big round of applause for everybody, and we just warm up the room, please. All right, thank you, thank you. So if we huddle up, I think we can turn this into a memorable event, and I think that could be the best decision for us, since we are also gracing the occasion. So I have a quiz for all the attendees, by the way, because there was no much interaction with all of you. All the panelists sitting here are fantastic, not just in their professional life, but in personal life as also. There are certain things which I've already asked them, which they do not know I asked them. Now, you guys would be basically be part of my poll. So there are different things which nobody knows about the panelists, all right? Something which they have not told to anybody, but only me, because they trust me more than anything, all right? So out of David Sankar, David Kellis, Natalia, Suchi, and Osman, who do you think is a professional football player or has been a professional football player in the past? You can raise hand or maybe shout a name if you know, or take a blind guess. If there are multiple, we can have a quiz here as well. So who do you think has been part of a professional football team in the past? Is it Usman? Is it David? I hear Usman and David's name. Anyone? You can take a wild guess, it's okay. I guarantee at least one of them is. Doesn't matter. that's a good. Yeah, it could be football or soccer as well.
David.
I have two Davids on the panel, by the way. David Sankar or David Kellis?
David Kellis.
David Kellis, one. Anybody else? Usman is one. All right. Anybody else? Any guesses? All right. So it's Usman Khan, who has been a soccer player in Thailand in his early days, and now in the US, of course, doing patent. Now, see, I don't want to bore you with the normal introductions, because all of you can go to their LinkedIns and see, and these guys will, of course, introduce themselves in the later half. Okay, going to the next one. Who do you think is a singer among the panelists?
Not me.
All right. If singer is difficult, let me just go to the dancer. Okay. Who do you think is the best dancer among us?
A singer and dancer?
It could be. Yeah. It could be. What? All right. So, except Usman, now you can guess anyone. David Kelly, Sankar, Natalia, or Suchi. Who do you think is a dancer, professional dancer, or a good dancer? Somebody who loves dancing as a hobby as well, yeah. Yeah, take a guess, quick, quick, quick. If you don't guess, then I'll have to pinpoint and ask you. Anybody from this side? Take a guess. Suchi? Okay, that's one. Yeah, it could be, of course, it could be me as well. You can vote me as well. From this side, any guesses? That's the correct answer, guys. That's the correct answer. Natalia is a good dancer. Yeah, and the next one I have is pretty interesting. I think you guys would know by now about this person. So this guy holds a Guinness World Record. Who is this person in the panel? Someone in the panel holds a Guinness World Record at the age of 14. 1-4. Any guesses? It is one of the Davids, by the way. No points for guessing David, but one of the Davids, yes. Is it David Kellis or David Sankar? Now, by the show of hands, we can just vote. It's easy. Don't Google, guys. Or ask ChatGPT. All right, so it's David Sankar, yes. Before joining Patent World, he has a Guinness World Record on himself. At the age of 14, he memorized the pi, the number. I only know 3.14, and he knows up to what, 500 or 1,000? It's 10,000 at a time. He remembered all of that, and he had a world record on it. Yes.
20,000.
So, yes.
20,000 now.
Yeah, and wow, one interesting thing. You know, somebody flew all the way from the US to Dubai by a plane which he can fly himself. So we have a pilot sitting in the panel. Who could that be? I already gave the clue, by the way. So it's David Kellis. He can fly a plane as well. Of course, he didn't fly as of now because his dad is yet to make the plane, which he wants to fly first. And yeah, we have a creative person in the room. On the panel itself, she likes to, all right, my bad. She likes to paint as well. So that's Suchi for you. Apart from their normal day-to-day IP role, these are some of the good things which nobody knows about them. So I thought maybe I'll share them with you so that now you pay more attention to what my esteemed panelist is about to say. All right, thank you. So see, today's topic is pretty interesting, like international patent protection, challenges and best practices. This is something which we anyways do very often in our day-to-day lives. In fact, everybody in the room has also been helping their clients with all the challenges and using best practices overall. We have already had too much of AI in Dub AI, the place we are in, right? So moving from that, I just want to understand, because I have a very diverse panel here. Suchi is from India, David Sankar as well as Kellis is from the US, Natalia is from Denmark, Copenhagen, and I am also from India. Usman is also from the US. So we have US, European as well as India, 3 jurisdictions, and 3 of the most prominent jurisdictions, I would say, when it comes to patent protection overall, except China, Korea, and Japan. And we will have, of course, our share of thoughts to be shared on the platform in terms of how the overall IP landscape globally is shaping, in what particular direction it's going, and what is there for all of us to learn. But something which is pressing, which is AI, nobody knows, like David said, I will not even want to bet on it for the next couple of years. So what are some of the best practices which one should adopt? Since we have no clarity, would you guys like to share some of the practices which you are adopting in your firm while advising your clients in drafting good quality patents which can get approval in almost at least these 3 jurisdictions where we are talking about, US, Europe, India, considering all the jurisdictional experience. So I would like to ask all of you, one after another, to share about your thoughts on the best practices for the AI-related inventions or the software patent drafting. You can start. We can start with you, David.
Thanks. So it's great to be with all of you and with my esteemed colleagues here on the panel. I think this, for me, I think this question goes beyond AI, right? And it's a question that applies regardless of the subject matter that you're trying to protect. And what I've seen, I should back up a little bit and say that I spent the last 3 years until June of 2024 living in Brazil, working on behalf of the U.S. government as the intellectual property attaché for the USPTO. And when I learned a lot about the Brazilian patent system, and of course we have some Brazilian attorneys here in the room, one of whom we heard from earlier today. But when I would come back to the U.S., I found that many attorneys had a perception of what things were like in Brazil and what the current practice was like in Brazil that was very distant from reality. And so what I wanted to say is it's important for all of us to make sure we have up-to-date information about the jurisdictions that our clients are interested in seeking protection in, because there's just no way for me to be an expert in the law of all of the countries, where protection might be relevant. And so I think I can save clients a ton of money and a ton of anguish if I'm willing to go talk to someone from that jurisdiction and say, hey, what do I need to keep in mind as I'm drafting this patent application that will be filed in your jurisdiction? And doing that, you can find out what's not even patentable. You can find out maybe that you need to include some content that you wouldn't have included otherwise. Maybe you need to include some draft claims in the specification that can be moved into the claims when you file in a different location, right? All those kinds of things. And I think that's true, again, regardless of whether you're talking about AI or not.
Interesting. Usman, you would like to add something to that?
Yeah. Yes. So
maybe we can just do this.
yeah, so I think ultimately any global portfolio will involve, it starts with the client, right? Understand what your client needs. So that's going to be strategy. A lot of times the strategy is defensive in nature. Sometimes it's offensive in nature. You are going to pursue protection depending on the client's strategy. Budget is another thing, right? What's the client's budget? What forms can they afford protection, which are not? That can be dictated by business and otherwise. So start off with the client. Start off with what they're interested in. Second thing is understand the complexities that you may be involved in prior to filing anything. So for instance, as many of you may know, you cannot change an application typically after you file it. So if you know that you're going to run into certain issues like subject matter eligibility or other things like that, in certain jurisdictions, they pay more attention to that, right? So if I'm going to be filing in the United States and Europe and elsewhere, I know that in Europe, they prefer a problem-solution approach, right? So I'm going to add that into my application, even if I have to file in the United States, right? Ideally, you want to have one application that can work globally. So understand the various jurisdictions that you're going to be filing in. Understand that some are followers of others. Understand how you can leverage Patent Prosecution Highway and other programs like that, and create a filing strategy, right, based off of those things. Something else to keep in mind is when you're filing in a lot of jurisdictions, translation becomes important. So not only in terms of cost, but also in terms of like paying attention to little details. One example is, for instance, the case got translated, went to another jurisdiction, and the United States are litigating it. It came down to claim construction. Essentially, what does a certain term mean, right? Certain term, the claims, what does it mean? They went back to the translation. In the original text, that claim wasn't even, that word that was at issue could not even be found in the original text, right? So when you're dealing with international applications, pay attention to translation. Don't just fish it off and expect that the translator will have done their job. The translator tries to do their best job. It doesn't mean that it's legally sufficient, right? So there's a lot of complexities involved. You can also consider timing. So since until 5-6 years ago, Australia was a venue that would be considered to get a quick allowance. Not so much anymore. But so you're going to file overseas in multiple jurisdictions. File in Australia. Even if you don't want coverage there, file there. Get the approval, use the PPH, right? the strategies like that you could have pursued in the past. It's changing, every year it's changing. So understand the dynamics of the world that you're going to be filing in, and then pursue that with all the various parameters in mind.
Sure. Sorry. So just to add to the point, to both of you, what you said, two very important points. One, hello? Yeah. So one, you should know the claims that you're drafting. Second, most important, you should know the countries where you need to file much before you have actually even gotten the application to start drafting. Now, when I say about India, there are two things which are very, very peculiar, which largely come as a shocker to people at a later stage when they come for a national phase application. So there is a section in Indian patent practice, which is section 59, which talks about the fact that if you were to file an application, the national phase entry in India, with a particular set of claims, then later on, the only thing that you can do is certainly narrow it down. But unlike if I have to go and file an application in US or Europe, I have the flexibility of amending the claim completely. Unlike that in India, you can only narrow down by way of adding limitations, but you cannot go ahead and remove any of the limitations which were there before. Similarly, I think one of the most dynamic component, which of late I'm seeing as evolving in the practice, is the tool of sufficiency, which is there in the disclosure. A lot of the times people assume what qualifies as disclosure or the level of disclosure in a patent application is pretty much same or harmonized, which actually is not the case. Europe has a different requirement. US has a certain requirement. India has a certain requirement. There is overlap, no doubt. But deciding upon, I do understand practically it may not be possible always, but having a first-hand information about which are the target countries where an applicant would likely be filing, and knowing the laws, accordingly devising your application is certainly something that can save you a lot of money, that can save you rejections, and it could just be something that can also take you away from some of the shockers. So India doesn't allow a method for treatment claims. But regularly, when a national phase application comes, which is full of method of treatment claims, it's just a rejection that is being issued. The courts of late have now intervened, and they have allowed that much of leeway, so to say, saying that this was not really an applicant's fault, that they included only method of treatment claims, while their application or the disclosure also has some system or the composition limitations. So because they chose to first, they are US citizens or European citizens, they chose to file it out there first, and now they've entered India. Because the law requires in India that you can only go ahead and file as-is claims in national phase entry, there has to be a flexibility in Indian law that it should allow them to convert those method claims to system claims. However, if you look at the initial practice which was there, the practice actually has got a few rejections or refusals done. Yes, the courts are a very good friend of late, but can every applicant go and litigate is certainly a question. So I think knowing the law of the land, likelihood at the time when you're planning to file in a particular country is certainly helpful.
Well, I don't want maybe to go too deep, but I would like to second everything that I heard now, because we discussed it a lot during the breaks also, that we have very crucial points where we are very different in the perspective, right? So you cannot correct something in Europe sometimes, although you have the grant in US, and we see it a lot, because there is no basis for amendments. And this is where Europe is very crucial, is how you may actually amend the claims, that you need the basis for every single feature in combination with other features. So I think this is just one example, right? I don't want to go to all the, maybe at least by now, to all these examples. But I think I totally agree with this, that you need to define at least the landscape, at least approximately where you want to go. And also, the very important point of their budgeting was touched, and some of the applicants, in my experience, they're really scared when you say to them, oh, it's regional thing, it's local thing, right? You cannot get, I still get this question sometimes, you cannot get one patent everywhere, right? You need to spend a lot of money on this, and people are scared because they understand there should be a lot of specialists involved, maybe even before drafting, as we discussed. But I think we have so many instruments now where we can defer the cost, actually, right? We have PCT filing. We don't have to go to the PCT filing immediately. We can go with the national filing. In some countries, they are cheaper, right? You don't have, in all the cases, to go to the EPO or to file in Europe. Maybe you can choose one country which is most important for you and then extend this time for you before you understand your own strategy. I think it's especially critical for startups, which are still maybe unsure which jurisdictions we need, where we should go, whether we need the patents or we need just maybe the publication in these jurisdictions to protect ourselves, right? Like preventive publications and all these kind of things.
All right. Good points. Good points added. So, David, apart from the sufficiency disclosure, the cost, the budgeting, the analysis, which everybody spoke about,
Yeah.
I have one question to you, which you can also include in the answer. What are the factors which influence examiner to give an early allowance for AI-related or software-related inventions in the US? If you can touch upon this topic as well while you answer.
You want the magic answer, huh?
Yeah.
If there was one. Well, before I touch that, I was just going to say, so as opposed to Europe and China, which require, literal support, and, you can't really change things. In the U.S., there's a lot more flexibility on things. And I think for someone who's, practiced in the U.S., it's somewhat disconcerting to say, what do you mean I can't do this? And a really good example that I want to bring up is, to file multiple dependency in the U.S. is exceedingly expensive, so nobody does it pretty much. But if I say have dependent claim 2 that comes that depends from claim 1, I have dependent claim 3 that comes from claim 1, then of course I could combine the content of claim 2 and 3 together. Except in Europe. The answer there is like, well, you didn't say you could combine those two, and I've run into that, and it's like, and to me it sounds absurd, but it's like, okay, well, but that's what the rules are. So from a U.S. standpoint, sometimes the best way to address that is, we really would like to have multiple dependency. So one way to do that is actually to file a provisional application. Even though you've drafted the whole thing, it's a full application, file a provisional application with multiple dependency on all of your claims so that you've got everything done. You file that, and then the next day you file the U.S. utility application, and then you don't have any question about whether there's support for these things or not. So that's one thing that I have done. And then your question was to getting early. The most magical thing that I have found is actually to file using track 1. And the advantage of that is, first of all, you get an office action very quickly. I found like 2 to 2.5 months. But also, my experience has been that the examiners who handle the track 1 cases are more inclined toward allowance. And therefore, I've had multiple cases where I've got first office action allowance on something, even in a recent one that I thought was going to be tough. I thought it was going to be really, really tough, but I got a first office action allowance. So if you really want something quick and good, pay the, even for a large entity, I think the total cost is about $4,100. If you're a small entity, which means less than 500 employees, it's about $1,700. And if you're a micro entity, it's about half that. So it can be a very valuable thing.
Yes, precisely. Thanks for sharing that. So I think what we get to know from all of you is that having a sufficient disclosure is important. Having clarity on the jurisdictions where you seek protection is very important while drafting a robust patent application, which can pass through almost all the country's examination procedures. And having a clear scope defined, each and every terminology is defined, is also very vital. And having a right strategy to get into these countries in terms of cost, in terms of timelines, in terms of multiple priorities and dependencies is also something which is vital for all these applications to be considered before filing. That's pretty much what everybody has shared. Yeah.
One small thing to add, other than the basis for the amendments, one small thing, if you are planning to file in Europe, it doesn't harm, it helps in most of the cases to add technical effects, so that you have it not only in your head as you have it in US, right, but you have it really in the application, and even not for the main claim, but for as many single backup options, let's say, which you can imagine.
Right, precisely. So moving on, I have next question for the panel is, how important is a sufficiently disclosed invention disclosure form is when it comes to drafting a robust patent portfolio, and what measures one should take as a patent lawyer to get most of the information out from the inventors, considering they shy away from giving you the information when you ask? How do you tackle this situation in your day-to-day work? Usman, we can start from you on this.
Yeah, probably it starts out first and foremost with trust, right? You have to, as counsel of your client, have to have their trust. And when you have their trust, they're going to feel more confident in divulging information to you, right? Because as you're alluding to, sometimes you do come across certain clients, they may not be as exposed to the world of IP, and they're reluctant to share their sensitive information. And they feel vulnerable that they're giving up this information to the public. So there's ways to mitigate that, but it starts with the human-to-human interaction, which is, let me reassure them, let me earn their trust. So their client, you earn their trust first. That's the first thing. Second thing, how can you make your client's life easy? That starts out by asking the right questions. Questions that sometimes they themselves don't think about, right? So for instance, for most inventors, their invention is the greatest thing on earth, right? You may not share that view as your counsel. And the market may not share that view from their counsel. But it's important to understand their view, right? And then it's important to kind of merge that with the market expectations or what's out there. So understand what is great about your client's invention, and then find a way to incorporate that into the application and get sufficient disclosure, ask the right questions, right? And amongst the right questions, to your point, it's like ask them, okay, what's the problem here? What's the solution? What's the technical effect? A lot of times these basic questions will be overseen by the inventor because they're so involved in their invention, right? And sometimes they're dealing with multiple hats, right? There's the business hat, the marketing hat, the inventor hat. So you have to guide them to put on the right hat, right? And then ask them the right questions. So invention disclosure, sometimes a form that you can put together and present to your clients, and that encourages them to provide the kind of information that you think is going to be important. Part of that disclosure process, what's very important or can be very important is getting figures, right? You as a patent attorney may not always understand or graphically depict the invention as well as the inventor can. And as they say, a picture can convey 1,000 words. So you as an attorney can try to put claims that are masterful and all that, but inevitably you may miss some details that are actually relevant and you could later on rely on for amendment purposes or something like that. So getting a robust set of figures as part of that disclosure process is helpful, right? I would say these are some key elements. It's not all of it, but these are some of the key things you can start with to get the right kind of disclosure from your client. And I think when you've done it collectively in a sort of, earn their trust, ask the right questions, and then determine whether disclosure is sufficient, complemented by figures, you go a long way in getting what you need.
Interesting, good points. Sushi, you want to add something?
Yes, for sure. So there's something that I've seen has worked a lot for us. It sometimes helps to actually give them some examples about actual refusals which may have happened before the patent office. So rather than, because we have to appreciate the fact that these are hardcore technology people who feel they're the mother of the possession, and they don't want to really go ahead and easily divulge. Nothing bad on their part, it's just the protective nature that we have. So, and a lot of the times because of this, they don't even understand why we are asking. Trust, 100% gives them comfort. But for them to be able to even appreciate the context why we are asking, I have seen in my practice when we speak to clients and then we ask for particular information and they're still struggling to give that, we cite a few examples. Recently there was a case, and more or less related to the same technology area, saying this got refused because so-and-so statistics was missing, function was missing, or this kind of an exploded view was missing, these details. I think this gives them a sense of understanding to what extent this is mandated by law. This is not something that we are making up on our own. So this helps. The second thing that I think has also worked for us a lot is a lot of the times asking them to answer questions makes them feel, oh my God, this is like another headache on my head. But if you devise some tables which can pretty much capture the details that you would need, that you can thereafter build upon, and a series of conversations you can get clarified, that helps, especially for mechanical or for electronic inventions. I've seen, we have a particular tabular format that we have come up, which has given us great results. It has actually cut down the time that we're spending with them in getting the information. And it's also pretty easy for them to intuitively go ahead and provide the information. So some of the best practices that we go for.
Yes, because you asked about the disclosure form, right? How to make it. And I had an experience of creating, even like helping the client to create the disclosure form for the clients. And I put all the questions I thought important. Did it help me to avoid the personal discussion with the inventor? No. Right? So I think there's still, even if the answer in a very good way and explained, I think there is always something hidden. And the way I was taught, like when I was very young to draft, is that you try to ask maybe even the same questions after different angles to really come to these big key things, which, as you mentioned very correctly, right, you can use as backup option at some point. And I think what also is important is to remember when asking all this big question to ask the second question: do you want all of this to be disclosed? Right, because we ask as the patent attorneys a lot of questions also to understand, to be able to help in a better way. But maybe some of these things which we know actually wouldn't be disclosed in the patent application.
And just very briefly, I'll add one more idea, which is to ask the inventor, if you were your competitor, then how would you design around what you have come up with? And then you can get some additional detail to build out the patent application and help yourself in the future.
I was going to just say, too, what I found also is in many cases the disclosure form is just the first step, and it requires an iterative process. It's like, okay, I need to ask more questions, and then ask some more questions, which actually brings up something that I've asked some vendors to do, which is actually use AI to create a sort of an invention disclosure process, so that, and I think that that's quite doable. I haven't seen one yet, but I suspect we'll have something like that. If we're here next year, I bet we'll probably talk about that.
Yeah, so I'm already building that particular app. That's the reason why I asked this question, because almost all of the clients of ours do suffer from this problem that their inventors do not want to share much, and then we have to get into the probing role, and we keep on probing and asking questions, and some of the time it feels too much overwhelming for them to do, because filing patents is not in any software engineers or any product officers into KRA. So since it's not part of the KRA, for them it's a waste of time. But for the founders, for the leaders, for the management, this is something to show off. This is something which helps them to get funding, helps them to get eyeballs in marketing. So yeah, we are working on something which will help the inventors' life very easily, and something like a product which people can use on the go. They can talk to the product itself, and come up with a great disclosure which will help people like us. And great point which you shared, Suchi, about showing inventors the possible rejections which are occurring. We do it the other way around. We show them the approved application saying that, oh, this is what you are missing right now. So if you can provide details like this, it can be helpful. So again, the same part of the same coin, different side of things, but yes, definitely. And asking something that your competitor would use to bypass your own invention is a great brainstorming exercise, I would say. Definitely, I'm going to try that. Thank you. Thanks for sharing that. So moving on, since we already spoke about some of the cost aspect as well in the opening remarks, how do you think PCT as an option or as a protocol should evolve and include more regional organizations like EPO, ERIPO, and others to benefit the applicant? Right now, people only use that to extend their times. But what are the hidden advantages of having a PCT application, and what is the particular timeline in which one should do it? Because there is an option of directly filing a PCT, non-provisional and provisional as well with the IB. But I think very few people or very few lawyers use that as an option. So how do you think PCT can play a vital role in reducing the cost burden to the applicant, be it small size or medium size or the large size? This is something which I would like you guys to answer. Yeah, you can go ahead.
You just remind me of the maybe important point. You can, like, where I see the real speeding of the process is when we have the PCT application, which is filed within the EPO. Because then the search that we get from the EPO, we can get, like, the first thing in the original phase, we can get the decision to grant, actually, the intention to grant, right? So it's what really helps. If, as when we see it from other jurisdictions, for example, we have a lot of Chinese PCT applications filed within the Chinese office, and then we always have the extra search, which is not always as positive as the other one. So if this is one of your main jurisdictions, maybe it makes sense to use this, to go to the specific office.
I'll just like to extend this point. Certainly, this is one of the most important consideration. There are certain patent offices where if you've selected US or Europe, and I think this varies from country to country, there is a list out there. If these are your search authorities, then the national search stage is completely waived off. So if you have actually US as the search body or Europe as the search body, then one, your fees reduces, the time tremendously reduces. In our case, for some of our clients, we do exactly this. If they have a preference for filing in US or for preference for filing in Europe, we typically try and choose one of those as the search bodies. Because talking strictly about India, well, the Indian Patent Office will do their search for sure, but there is certain reliance that they have on the search reports issued by them. So in one go, you're able to actually have a lot more that you can cover.
Good point.
Just, this is a very minor point, but you know, if you're talking about cost savings to applicants, if you file the PCT application in the US, then it's cheaper to file the national stage in the US, right? So there are some things you can do cost-wise there. And maybe stepping back and looking at that question a little bit more broadly, you know, what systems exist to help applicants? As has already been mentioned, there's the PPH, there's PCT. There are ways to speed up examination in lots of countries, and many of those ways are free. Many of them cost a little bit of money. Some of them cost a lot of money, like Track 1. I think Track 1 is the most expensive way to speed things up, but even USPTO has free options for accelerating examination. And then there's also ways to slow down the examination. And so maybe an applicant needs to get something on file but really doesn't have money to spend on it. Well, at least in USPTO, you can request up to a 3-year deferred examination after you file the application. And that can, you know, save money for a long time, as long as you don't have to then go elsewhere. But just some ideas.
Just one very important point, specifically and strictly speaking about India. So in India, to expedite an application, there are only certain requirements, one of which you can go for. So for a large multinational, if you're not a startup, you're not MSME, then the way to expedite the application could be to actually file a PCT application and designate India as an ISA, and then you can get your application speeded up. Because other than that, you don't really have an option of getting a fast-track grant out there in India.
Yes. So if you use this, you choose India as ISA, then you can expect a disposal of the case in just 12 months, which is fastest when it comes to any country. I think track 1 also takes some similar time, but track 1 doesn't have a deadline as to which or the timeline in which the prosecution should complete. While in India, the guidelines given to the examiner is of 12 months from the date you file the application itself in India. So that is something which you can do. Yes, interesting point. So something which I want to understand, David, from your side, since you have been into in this patent world for a long time. So how do you look at US 103 when in comparison to the technical problem solution approach in EP, and how do you think there are similarities between the obviousness rejections in the US as well as in the EP when it comes to file? I'm asking this question because most of the applicants who want to file in multiple jurisdiction, they often face this problem. So how do you look at this?
I
mean, you can either provide your comparison on the obviousness front from the US, and if you have experience of talking about the same thing in the Europe, that's okay. Or you can just talk about the 103 in the US. We can ask Natalia about the problem solution approach in the Europe.
Yeah, I'm not sure how many. I mean, obviously, we get lots of 103 rejections, and there's no limit to the number of references that can be cited in the U.S. And that sometimes surprises people. It's like, an examiner could cite 5 references, 6, 7, 8, and that's perfectly fine from a legal standpoint. And it's like, well, to my mind, it's like, well, if it takes that many references to combine to make this, that probably wasn't very obvious. But other than that, I'm not sure I have any specific strategy. I mean, I was wondering, do you have any thoughts there?
I mean, and I'm sure others have thoughts too, but I think the reality is that you have to understand both systems and you have to be ready to make arguments under both systems, right? And if you can think about that while you're drafting the application, all the better, because then you can lay the groundwork for those arguments. In the US, you need to be ready to talk about secondary conditions of non-obviousness. If you have to get there, right? Ideally, you can just address the actual substance of the argument, but if not, then maybe you need to go to other reasons why it wasn't obvious. And then I imagine that in the EU, there's similar things to think about.
Yeah.
Yeah, for those who are not familiar with U.S. prosecution, there's section MPEP 2143 that sets out the various rationales for obviousness. It took its lead from a KSR, for those of us who are familiar. But 2143.01, I believe, it offers methods that applicants can use to overcome obviousness rejections. So to the extent you can leverage that guidance to some point, that can be helpful for folks.
Yeah, my experience is sometimes I've laid out really good arguments based upon that, and they just ignore me. And in fact, it's been so bad in terms of saying the rationale for combining is pretty much I don't even argue it anymore. It's like okay, I've got to find a claim element that's missing because my success at trying to say no, you can't combine these things, it just goes flat. And either I'm just not very good at it, or it just doesn't work.
Yeah, Natalia, you want to add how EP looks after this in terms of obviousness, or the couldn't approach, which is defined properly in EP?
Yes, but I think actually I'd like to hear also the view of the U.S. attorneys, because I think this is the people who challenge even more with this, right? And I think that the key problem with EPO in comparison with US, you cannot correct, like you can correct nothing, right? You can say, well, but I meant it when I drafted, right? But it's reasonable person would understand it. I mean, we use these arguments, we try, but, and we like success at some point, right? It depends, of course, of how, what you do, how you convincing you are. But to be really on the safe side, that's the key problem, that you need all these combinations. And I think the problem, when we talk about the problem solution approach, also Manuel mentioned it in the previous panel a bit. On the one hand, I think it is special what we have, but on the other hand, I think it's kind of the work of the European patent attorney to take what we have and to help formulate this problem solution approach in the correct way. So, and what I have in my experience is what really helps with the US applications filed in Europe is cooperative work of US patent attorney working, or maybe even drafting this application at the best case scenario, and the European patent attorney. Because then we can really together come to the best version of technical effects, best version of amendments, and this problem solution approach together.
I agree. So, I mean, there are different strategies, of course, which all of us can adopt when it comes to multi-jurisdictional patent portfolios and maintaining those global portfolios. But what are some of your observations, again, specifically to your jurisdictions, which you have observed, or common pitfalls which applicants should, or the foreign patent lawyer should be aware about when specifically enter the national phase applications in your country? From the prosecution standpoints, we have of course spoken already about the sufficiency disclosure, the law of the land, but what are some of the hidden things which very few people do know about your local jurisdiction, which they must while designating your countries? Do you want to touch upon that as a topic, as a point? Anything specific for India, Suchi?
So I think one part I had just covered, which was about specially method for treatment claims, because there is a big furor about it. There are quite a few applications which have gone down the drain, some of which were repealed and could stand the test of time, so the courts actually ultimately gave a positive decision. So one piece of advice would be that when you're filing, while it is mandated by law, that your claims have to be identical with what was filed before the PCT office. It always helps to actually see if there's any sort of amendment that is required that you should file immediately thereafter, if at all it falls in any subject matter which is excluded. That being one. The second thing I think largely that we have to keep in mind is that I think to a great extent I could say that Indian law is catching up a lot. So till some time back, divisional applications were not allowed in India. So essentially, unless and until you had a second set of claims in the application, could you only divide that out later on if there is an objection from the patent office, or voluntarily also, only if the claims were there initially. But now, with some changes recently, the divisional applications could be something which are required. I think a lot of the things in India which are catching up when it comes to US and European practice are before the courts. But largely my point would be that please do get your claims vetted. And if there is a requirement of amendment, it's better not to wait for the office action, but file form, amendment form or request and make respective changes. But one important thing, post the decision which is grant, is that India has this requirement of submission of working of patent, which if not being complied with, has great ramifications. So that is something I don't think is there out there in US or Europe as a necessary or mandatory step to be taken. But from the Indian context, that's important. That is mandatory.
Yeah, I mean, in India, we also have the requirement of providing statement and undertaking for foreign filings and the status of the respective application in other countries. that's also one of the ground for the objections as per the law. So I think that should also be taken care of. But apart from that, US, Europe, any specific thing which you would like to highlight, which one should be aware about, which is like a pitfall?
So it's completely understandable why this happens, especially coming from jurisdictions that don't allow claim amendments after filing or only allow narrowing claim amendments, and also for cost reasons. But sometimes I see applications come into the U.S. that are extremely thin, right? So they have enough support for the claims and very little else. That's really hard from a U.S. standpoint because in the U.S., you can put the kitchen sink into the application and then draw anything from that sink to put into the claims to overcome a rejection. And so filling out if you know you're coming to the US, then filling out the application, the specification I should say, with as much detail as possible, alternatives, different levels of detail, all of that can be very helpful in terms not just of getting your first patent issued, but then filing a continuation, which again is somewhat unique to U.S. practice, but filing a continuation, whether that's to keep an application alive so that you can go after competitors if and when you need to, or to build out what we call a patent thicket to make your position stronger if you ever do have to enforce that application.
Yeah. So for a lot of clients, stepping into the IP world is it's like going into a different universe, and it can be a little overwhelming at first. And I think one of the biggest mistakes a lot of clients make is not fully understanding all of their options, right? What are my options if I want to pursue offensive strategy, defensive strategy? What are my options to accelerate? What are my options to slow down? I think you mentioned earlier there's a process in the U.S. to slow down prosecution. Many attorneys don't even know that, right? So make sure you have all the options, because that's going to be informative of how you use your budget, right? So you can use your budget in a conservative way or in an explosive way, right? Really up to you. And you have the ability to, at different stages, accelerate and decelerate. So for instance, we have done things like we have a regular application, it's just not proceeding, right? And you sort of missed the deadline for track 1 filing. Okay, file a con, put that on track 1. Within a year, you get an outcome. And that option is only available once your client is willing to pay that extra $4K or things like that, which maybe at the time of the earlier provisional filing, they didn't have that kind of money. Right, so understand your options. The other thing I'd suggest strongly is always work with a local attorney, because not everyone's going to understand these tricks, whichever jurisdiction you're in, not just the U.S. So I think between these two things, good hands to move your case forward.
Good points.
Yeah. The other thing that I've seen sometimes, particularly with my Japanese clients, is they're frequently very baffled by the rejections for subject matter jurisdiction. And it's like, to them, it's just like, what is this doing? It's like, well, regardless of whether you agree with it or not, that's the reality that we have to deal with. And so there was actually an example where a client they were going to file in the U.S., and I looked at the claims and I said, these are absurdly vague. We're not going to get anywhere near that. And so I amended the claims, and then it was like 9 months later, they said, oh, you basically wanted to revert back to what they started with. And it's like, this is a bad idea, but that's what the client wanted. So I think the subject matter eligibility is something that a lot of people don't understand. It's like, we have to deal with it. It's like, yeah, there's a lot of things bad about that, but that's what we have to deal with.
Interesting. Very good. So we are towards the end of our discussion. One question which I want to ask all of you guys is, 5 years from now, how do we look at our respective jurisdiction evolving into the IP world? Is there a possibility of collaboration at a broader level? Currently, we have IPV IP 5 countries as US, Europe, China, Korea, and Japan, can we see more and more countries joining hands together at the global level in terms of smoothing the prosecution? Or what are your thoughts on 5 years from now? We are in 2030, same day, 5 years from now. How do you look at your country's position in IP?
Somehow I want to start with the computer-related, software-related applications, but I'm way too optimistic, I must say, right? So please divide what I'm going to say. But I think that, and of course it depends on the patent attorneys and us, and we now have the UPC court in Europe, which will also influence, of course, the practice. But I think we have this artificial intelligence area evolving, right? We have a lot of applications which 10 years ago we couldn't even imagine that we can get this protected. And I think now we always say it is difficult, but we don't say it's impossible anymore for many things.
Right.
And I hope that we, as patent attorneys, also working all together, maybe in different jurisdictions, giving the impacts and seeing the case law and exchanging our opinions, we can actually at some point move this, because I think the patent offices, they should be in line with the technologies, right? They shouldn't be blocking the development.
Right.
And I think we can work on it. So we're trying at least.
All right. What do you think about how US will progress in the next 5 years?
So there's two sides to it, I think. On the back end, for example, let's say examination purposes, there's certain jurisdictions that they're much stronger in certain areas. So for instance, if you're doing semiconductors, the prior art landscape in Japan is incredible. Not so much in the US relatively in other places. But as you see the advent of AI and its use in prior art searching, I think that's going to cross boundaries a lot. So the advantage maybe certain jurisdictions had for certain subject matter competence will start shifting around globally. So you're not going to get that same monopolization, or for lack of a better word, just strength in one. So I think the services at the back end that patent office offers, those will start being shared, right? A little bit more. As for other types of cooperation, maybe I'm not as optimistic as you. It just seems like, there's generally, I think globally, a more trend of nationalization, right? And so, not to speak broadly out of time, I'm not a politician by any means, but there seems to be an inclination to not share as many resources, right? So that might be a little bit of an impediment. But you may see strategic partnerships at a sort of a bilateral basis, right? I just don't see that sort of international global cooperation making too much progress in 5 years.
Okay, all right, got it. Yes.
Sure. So for India, I would talk about strictly from the perspective of what I see in next 5 years for India, and then India vis-a-vis the world in terms of cooperation. So when I came into this practice, which was early 2000s, in a year in litigation, if there were 10 cases, it was a good number. And I'm talking strictly about patent litigation. If the filings were about 20,000, that was a great number, okay? So seeing the shift from there to where we are, where I think the awareness levels are great, a lot more is being done, ecosystem is being built, the startup culture which is being much talked about, and more so not from the perspective of startup, but from the perspective of the kind of technical research and contribution that the companies are doing. And which basically is translating into absolutely great IP. So today we are talking about, just within these 3 years, India used to have in 2022 about 50,000 patents with 60 to 70% national phase filings. And today we have crossed 1 lakh with 55% native Indian filings. There is a transformational shift. Could I talk about the quality is the same? No, I'm sure there's a lot of catch-up to do. But the courts are doing a brilliant job. a lot of the reliance is certainly coming from the US and European patent practices, but at the same time, there are a lot of the things that they're building on their own, depending upon what the local requirements are. So in short, if I have to summarize India, where I see it in the next 5 years, given my 24 years of experience, I feel that we would be at a much better stage from where we are today in terms of practice, in terms of quality of examination, in terms of court decisions, and also in terms of litigations and enforcement. If I have to look at the global level and the cooperation, I think on and off, there are a lot of things that keep happening, just like we had PPH, which is now closed. This was with Japan. Or when you talk about something like AI, which certainly cannot be singularly handled by either Europe or US or India, this is a global phenomena, right? I do think the technology is evolving. There will be things where there would be more cooperation and cooperative approach between the patent offices. What the test would be and what the guidance would be, I think is still very open. But if I talk about anything driven to AI, nothing has come to the courts, but largely the technical effect approach is what the Indian Patent Office has been taken. So yes, I do think that on certain points, there would be more harmonization of the approach and interpretation of law. In terms of, would there still be open challenges? 100%.
I'm with Usman in terms of lack of optimism for much more global cooperation in the upcoming 5 years, but I do think that we're going to start to see a widespread bifurcation between AI-written patent applications and human-written patent applications, and more specifically, I think that we're going to start to see companies, law firms, offer a cheap route and an expensive route. And the cheap route will be your patent will be drafted by AI, and humans are not going to get involved. And then, responses will also be handled by AI. And then the more expensive route will be, we're going to have our attorneys draft this application for you, and you're going to get the benefit of actual human creativity for that. And I think that's going to enable a lot more people to get patents, and it's going to enable companies to get patents on things that they normally wouldn't spend money on today.
David, you want to add something?
It's interesting how the three of us from the U.S. are very consistent on being pessimistic. I'll just say, yeah, I agree with that. That's like too much. The U.S. and EPO examiners and examiner divisions think too highly of themselves to be willing to work with others as much as they should. I think it would be better that we all work together, but I don't see that happening in the near term.
All right. Yeah, sure, you can.
This question for you. This is a great point. Follow-up question was, do you know of insurance companies that are offering insurance in case one of the AI-generated applications by a law firm is a subject of a suit?
I don't, but I have to think that you could draft an engagement letter that
using ChatGPT.
I have to think that you could draft an engagement letter that would make it very clear to the client that that's what they're getting. And maybe a company would do it on their own first, right? In-house counsel could use ChatGPT to put in all the invention disclosures for the things they're not going to pay an attorney to draft applications on, generate the applications, file them, and see what happens, right? And then there's no liability issue there.
The 5 years going from now, what I think is we'll have AI examiners as well, appointed by all the patent offices across the globe. Because what recently happened, I think 2 years back happened, is Chinese applicants flooded USPTO gates with multiple trademark applications. Those were all bogus without prosecuting them, which slowed down USPTO. I think the PTOs are already working in the back end to evaluate the AI-generated applications and kick them off because, the previous topic already discussed this at length. So that could be something which I am really looking forward to, the AI examinations. And if that happens, then I don't think we need to have long examination queues either. Currently in India, we are getting the patent approved in less than 12 months. I think it should come down to 6 months. There should be, of course, some of the amendments to be made in the law, but this can really happen. US Track 1 is helping people to get the first office action within 2-3 months of time. I think when you have AI examiners doing that, you might even expect it within 24 to 48 hours. something to really look forward to. I am really optimistic with that. And Suchi touched upon a very wonderful point about number of patent applications being filed in the country. It is close to 100,000 at the moment, but in the 5 years, I think it's going to touch the million cases easily, because India is going to become the hub for all the developments when it comes to technology, and get the advantage of all the geopolitical situation which is happening between US, China, and everything else. So I think these are great times we are living in. Suchi has been doing IP for almost 22 decades. I have been doing it for the last 1 decade, and I have seen remarkable progress in terms of global cooperation, in terms of the speedy timelines and everything in the country. And I think the next 5 years are going to be the great years for all of us to live and breathe the technology along with the law. And I think we are placed at a very perfect location to discuss this. So thank you so much, my wonderful panelists, for having an exciting discussion, and thanks for being the giver. I mean, you have given all your secrets, all your secret sauce away, and I hope this should add a lot of value to all of our viewers as well. If anybody has any questions, the panel is open for taking a couple of questions now, or if any of the co-panelists wants to ask something to other, I open this floor for everyone. By the way, do rate me on my moderation skill on LinkedIn. That will really help me to understand and get the live feedback as well. Any questions from the back? There? You guys want to ask any questions?
I thought for sure someone was going to ask David to recite the first 200 numbers
Oh,
of
yes.
pi.
We agreed on this, David. Yes.
That'll only take another hour. No.
Awesome. Any other questions? All right. So I think we are good here. Thank you. Thank you so much.
Thank you.
Thanks for being the great audience.
Thank you, all the panel members, as well as the moderator. Now it's time to honor. So I would like to request moderator Priyank to honor Suchi Agarwal. Next is Usman Khan. And David Kellis. Thank you so much, all the panel members. Kindly come forward for the group photo. That's it. Okay. You can come in front. Come in front. Come in front. It will be good. Thank you so much.